Good morning, everyone. I'm going to be talking about aspects of the case. I can't talk about the entire case, but aspects of it. I was one of the witnesses in the case. So the title of my paper is...
Sorry? Oh.
I'm
sorry.
Are
you going to have
just me. The title of the paper is Fraser and the UCU, Anti-Zionism, Antisemitism and Racializing Discourse. In August 2011, Ronnie Fraser, acting through his lawyer Anthony Julius, filed a claim in the Central London Employment Tribunal against the University and College Union, alleging hostile environment harassment under sections 26 and 57 of the Equality Act 2010. He claimed that the union had created a hostile environment for him as a Jewish member, Jewish being a protected characteristic as both a race and a religion under the Act, by engaging in a course of unwanted anti-Semitic conduct that was informed by hostility to Israel and the Zionist project. In March 2013, the Employment Tribunal unanimously dismissed all 10 grounds of Fraser's complaint as unfounded and mostly time-barred. This paper aims to explore the contested meanings of anti-Zionism and anti-Semitism in the UK, using, in part, the idea of racializing discourse. Its principal focus is an examination of the arguments and judgment in Fraser and the University and College Union 2013. The key concepts and terms at issue here are contested terms. The concepts of anti-Semitism and anti-Zionism are neither univocal nor can they be isolated from the fields of practice and conflict, as was especially evident in Fraser and the UCU. Zionists rightly believe that anti-Semitism is implicated in contemporary anti-Zionism, because anti-Zionism is opposition to Zionism, which is the Jewish project of establishing, developing and protecting the State of Israel as the ancestral homeland of the Jews. This opposition is frequently expressed in the language of prejudice against Israel or the Zionist project. It was this meaning of anti-Zionism that was advanced by Fraser, his 34 witnesses and his legal team in his case against the UCU. And it is this meaning of anti-Zionism which may be found in the official 2002 definition contained in the report of the Berlin Technical University's Centre for Research on Anti-Semitism, drafted for the European Monitoring Centre on Racism and Xenophobia. It defines anti-Zionism as, quote, the portrayal of Israel as a state that is fundamentally negatively distinct from all others and which therefore has no right to exist. Anti-Zionists, on the other hand, evade charges of anti-Semitism by representing anti-Zionism as merely opposition to Zionism, and by claiming that Zionism is a political movement or ideology that is unrelated to and independent of a person's race or religion. This alternative version of anti-Zionism was advanced by the UCU and accepted by the tribunal, and this had a distinctly negative consequence for the outcome of Fraser's case. This is because the tribunal's characterization of Zionism and anti-Zionism as mere political ideologies was crucial to a central question before the tribunal, which was whether an attachment to Israel is relevant to Jewish identity. This question was central because to succeed in a claim for hostile environment harassment, there has to be a relevant nexus between the unwanted conduct and the claimant's protected characteristic. In this case, the unwanted conduct was hostility to Israel and Zionism, and the protected characteristic was Fraser's Jewish religious and racial status. Fraser argued that an affinity with the State of Israel and the Zionist project is an aspect of the identity of the majority of British Jews, who assume a certain obligation to support Israel and to ensure its survival as the ancestral homeland of the Jewish people. This does not equate to unconditional or unstinting support for the government of Israel or its policies, Rather, it amounts to a sense of connection with, or an affiliation to, Israel, and a sense of its importance in the context of Jewish history and the persecution of the Jewish people. For this reason, hostility to Israel engages Jews not only in conventional political terms, but also because Israel is an aspect of their identity. Indeed, the reason why the majority of British Jews are usually at the forefront of movements opposing irrational, disproportionate, and stereotyped hostility to Israel is because they have some kind of affinity to Israel. Accordingly, said Fraser, hostility to Israel engages his protected characteristic. The UCU, on the other hand, argued that many different positions are taken on the Israel-Palestine conflict, and specifically on the academic boycott of Israel, and that these are political positions which tend to be associated with distinct groups. Jews are represented in many such groups, and it therefore follows that any disagreements between the groups are political and do not touch on any protected characteristic, that is, on any religious or racial identity under the Equality Act. In other words, a person's political positions are completely independent of and not determined by their race or religion. There were witnesses for both the UCU and Fraser who demonstrated that not all Jewish people hold Zionist beliefs, and that many people who hold Zionist beliefs are Christian or of some other faith. Fraser countered that the fact that there is a range of views within the body of Anglo-Jewry on Israel does not override the argument that his protected characteristic is engaged when Israel is demonized. The existence of a group of Jews who are hostile to Israel and Zionism is not evidence for the proposition that an attachment to Israel is not an aspect of contemporary Jewish identity. These Jews are either marginal or non-normative, or the form their protected characteristic takes is in their hostility to Israel and Zionism. But the tribunal rejected Fraser's claim that an attachment to Israel is an aspect of Jewish identity. It said it could find no authority for the proposition that legal protection also attaches to, quote, a particular affinity or sentiment not inherent in the protected characteristic, but said to be commonly held by members of the protected group. The reason why there was no authority was because this was a case of first instance. It hadn't been litigated before. The tribunal could have stipulated that an affinity or sentiment fell within the scope of the protected characteristic, but it preferred to accept the UCU's range of views argument. Referring to a pro-BDS member of the UCU as Jewish, the tribunal said, quote, the claimant's main contention is that the conduct of which he complains was inherently discriminatory, in that it consisted of acts and omissions concerning the conflict between Israel and Palestine, and so related to his, although of course not every Jew's, Jewish identity, and as such, his race or religion or belief. The tribunal was then able to conclude that, quote, it seems to us that a belief in the Zionist project or an attachment to Israel is not intrinsically a part of Jewishness. This reasoning demonstrates how the UK anti-Zionist movement has successfully managed to separate Israel from Jews. It claims that Jews and Israelis or Zionists are two separate and distinct entities, so much so that hatred of Israel and hatred of Jews are considered to be unconnected. In this way, anti-Zionist expression and hostility to Israel has been normalised in the British trade union movement and on British campuses, and is not recognised as anti-Semitic harassment under Section 26 of the Equality Act. Indeed, the representation of Zionism as a political movement or ideology which is unconnected to race or religion allows anti-Zionists to deny anti-Semitism while representing Zionism as a uniquely racist ideology which secured and now maintains statehood by persecutory means. In the view of the UCU anti-Zionists, Israel was established by the dispossession of the Palestinians, was enlarged by aggressive wars, and is now maintained by the oppression and brutality, making Israel an illegitimate state. This anti-Zionism, which Anthony Julius refers to as progressive anti-Zionism, and Alan Johnson refers to as anti-Semitic anti-Zionism, is found predominantly among those on the far left of the UK political spectrum. It is these people, the far left, who dominate the UCU's executive, its activists list, and its annual congress, the place where they propose anti-Israel motions and overwhelmingly vote to adopt them. This anti-Zionism conceives of Israel and the Zionist project in partial and distorted form and, as Johnson explains, relies on a distorting system of concepts. Zionism is racism. Israel is a settler colonialist state which ethnically cleansed the indigenous people of Palestine, went on to build an apartheid state, and is now engaged in an incremental genocide against the Palestinians. This anti-Zionism is firmly rooted in the global BDS movement, and its political programme is the removal of Israel from the world stage. There have been various attempts to explain this left hostility to Israel and Zionism. One explanation is that the values of the left are secular, collectivist, internationalist and universalist, and are therefore at odds with what it perceives to be the Jewish values: religious, individualist, nationalist and particularist. This makes leftists oppose Jewish religious and national rights. Johnson explains the hostility in terms of a phenomenon known as anti-imperialist campism, which he describes as the left's raising of anti-imperialism to an absolute value and the reframing of Israel as the key site of the imperialist system. David Hirsch believes that anti-imperialist campism has emerged, quote, as the preeminent principle of the progressive movement, making hostility to Israel a key marker of political belonging. British historian Simon Sharma explains the left's hostility to Israel and Zionism in terms of post-colonial guilt, which, quote, has fired up the war against its prize whipping boy Zionism like no other cause. This would suggest that the normalisation of anti-Semitic anti-Zionism within the British trade union movement is partially explicable in terms of the left's distancing itself from a legacy of colonialism. The anti-Zionist separation of Israel from Jews provides the context and rationale for disagreement between Zionists and anti-Zionists as to what counts as anti-Semitism. This disagreement was a central issue in Fraser and the UCU. Fraser embraced the EUMC working definition of anti-Semitism, and his case against the UCU was based in part on its repudiation by the UCU at its 2011 Congress. Motion 70 had expressed the view that the EUMC definition, quote, confused criticism of Israeli government policy and actions with genuine anti-Semitism and was being used to silence debate about Israel and Palestine on university and college campuses. That the EUMC definition was used by Jews in bad faith to silence criticism of Israel had been advanced by UCU Joint General Secretary Paul McNee in 2006, when he told the All-Party Parliamentary Committee of Inquiry into Anti-Semitism that, quote, criticism of the Israeli government is not in itself anti-Semitic, and that, quote, defenders of Israel had used the charge of anti-Semitism as a tactic to smother democratic debate and legitimate censure. McNee's statement and the contents of Motion 70 reflect David Hirsch's Livingstone formulation, which is a very common trope of contemporary anti-Semitism in England. The Livingstone formulation is the charge that those raising concerns of anti-Semitism are doing so in bad faith in order to silence criticism of Israel. And as we shall see, it was also deployed by the tribunal in its ruling against Fraser. The UCU only regarded classical anti-Semitism, hatred of the individual Jew, to be genuine anti-Semitism. In 2012, it formally adopted the following definition of anti-Semitism formulated by the anti-Zionist Jew, Dr. Brian Klug, quote, at the heart of anti-Semitism is the negative stereotype of the Jew, sinister, cunning, parasitic, money-grubbing, mysteriously powerful, and so on. Anti-Semitism consists in projecting this figure onto individual Jews, Jewish groups, and Jewish institutions. The tribunal decided that it was not required or prepared to rule on the meaning or definition of anti-Semitism, including the EUMC working definition. Noting that some members of the Union did not like the EUMC definition on the grounds that it brands attacks on Zionism anti-Semitic, while others, such as Fraser himself, did like it, the tribunal concluded that there are legitimately held differences of view on what constitutes anti-Semitism and on where the line should be drawn in relation to when criticism of Israel becomes anti-Semitic. And that this, moreover, is, quote, the stuff of political debate. This constitutes a denial of anti-Semitism. By characterizing all criticism of Israel as free political speech, the tribunal was able to disregard as irrelevant all Fraser's evidence of anti-Semitism. In a pointed criticism of Julius's emphasis on anti-Semitism throughout the hearing, the tribunal said, quote, "We had to remind ourselves frequently that despite appearances, we were not conducting a public inquiry into anti-Semitism, but considering a lawful claim for unlawful harassment." The tribunal was further able to disregard Fraser's evidence of anti-Semitism as irrelevant or inauthentic by racializing Fraser and many of his witnesses. In her book, An Unfortunate Coincidence, Jews, Jewishness and English Law, Didi Herman notes the judicial practice of racializing and orientalizing Jews and Jewish issues in a range of English cases. She uses the term Orientalism to signify a particular way of characterizing Jews so as to mark them out as Eastern and un-English. This involves comparing Jews and Jewish practices to those of other civilizations, especially the Christian one, which is held up as eminently superior and is equated with that which is English. This is a racializing discourse because Jews and Jewish practices are understood and represented as inferior to Christianity and to Englishness. Accordingly, the tribunal applied unattractive characteristics to Fraser and many of his witnesses. Herman notes that judicial assessments of character are often dependent on notions of race. Their unattractiveness was found in their un-English behaviour, such as, quote, playing to the gallery, scoring points, ventilating opinions, and behaving in a tactical manner. The tribunal indulged in a good witness, bad witness distinction by juxtaposing their behaviour against that of the UCU witnesses, each of whom gave, quote, careful and accurate evidence and stuck to the facts. The notion of playing fair is a Christian one, and a sense of fair play is a deeply embedded English value. The exclusion of emotional witnesses for Fraser avoided the political colouring of their testimony, which was problematic for the tribunal. There are several other examples of racialising discourse in Fraser and the UCU. One is the tribunal's deployment of the Livingstone formulation. In an echo of the UCU's attitude, the tribunal characterised the case as one in which Fraser, his Jewish lawyer, and his witnesses wanted to abrogate free political speech in the Union in order to shield Israel from criticism. In ruling against Fraser, it said, quote, at heart, this litigation represents an impermissible attempt to achieve a political end by litigious means. This is a racialising discourse because it accuses Fraser and his team of playing the anti-Semitism card to prevent criticism of Israel. It involves anti-Semitic ways of thinking because it sees a secret agenda behind the charge of anti-Semitism, which is to silence Israel's critics. The spectre of Jewish particularism was a strong theme throughout the judgment. The tribunal characterised the case as one of Jewish particularism versus the universal right to freedom of expression, a right enshrined in Article 10 of the European Convention of Human Rights and protected under Sections 3 and 12 of the Human Rights Act 1998, and concluded that, quote, the narrow interests of Mr. Fraser must give way to the wider public interest in ensuring that freedom of expression is safeguarded. This reasoning suggests that freedom of expression cases, or cases that are characterised as freedom of expression cases, will, and indeed should, work against Jewish claimants. Jewish particularism was further evident in the tribunal's characterisation of Fraser and his team as opposed to pluralism and tolerance. The tribunal said that, quote, "We are troubled by the implications of the claim, because underlying it we sense a worrying disregard for pluralism, tolerance, and freedom of expression." The pitting of the Jew against pluralism, tolerance, and freedom of expression amounts to an orientalizing of the Jew, because these are universal rights and values that are associated with Western Christian Europe. In this way, Jews are represented and understood as inferior to Christianity and as Eastern in the sense of un-English. Further, because human rights are associated with the Enlightenment and with democracy, Jews are represented and understood as not fully enlightened and as undemocratic. This is a racializing discourse which echoes the tribunal's view that Fraser was trying to interfere in the democratic processes within the Union, which merely wanted to uphold the principle of free speech and provide an arena for members to engage with each other on matters of pressing political concern, such as the Israel-Palestine conflict. It was the spectre of Jewish particularism that was also responsible for the tribunal's rejection of Fraser's claim that an attachment to Israel is relevant to his Jewish identity. By rejecting the attachment of Jews to Israel, the tribunal rejected Jewish nationalism and Jewish particularism in favour of a raceless, post-national, post-Holocaust Europe with its guarantee of universal rights. This reinforced the tribunal's denial of contemporary anti-Semitism, because in the post-national, post-Holocaust Europe, anti-Semitism is considered to be a thing of the past, overcome by the defeat of fascism and the development of the European Convention on Human Rights. The tribunal's racializing discourse reflects anti-Semitism in the UK, which is a phenomenon about ways of thinking about Jews. As Hirsch has noted, Jews are described, imagined, and suspected in a certain way by people who consider themselves to be good and clever. To conclude, I hope I've brought out the contested meanings of anti-Zionism and anti-Semitism in the UK, as well as anti-Semitic ways of thinking, by reference to the UCU case. Unfortunately, since the election of Jeremy Corbyn as leader, the UCU's understanding of anti-Zionism and anti-Semitism is increasingly represented among members of the Labour Party and in the Academy. It would appear that the tribunal's anti-Semitic ways of thinking are carried by people who believe themselves to be virtuous opponents of anti-Semitism and who therefore refuse to acknowledge their own anti-Semitism even when it is pointed out to them. Further, we can see from the judicial discourse that there are certain dominant and problematic assumptions in law. Even if there are not always out-and-out racialized assumptions, there is a certain kind of orientation that inevitably excludes, marginalizes, or silences the Jewish experience.